So, Horace, you raised the state sovereignty question and the fact that there is, I don't think it's disputed that the Voting Rights Act is a kind of novel approach to dealing with different states and the notion of covered jurisdictions. And one of the arguments that the folks who want to strike down the Section 5 have made is that this differentiation is a threat to a basic constitutional bedrock principle of state sovereignty. And the people who say, well, that's justified by the differential conditions. My question to you is, it seems like a strangely perverse argument to say, well, discrimination is happening in places like Michigan and Ohio, and therefore we should get rid of the stuff that's working in the other places. And then the second question is, would you be okay with a Voting Rights Act that extended to the whole country if that's the constitutional principle that is the thing that you think is threatened by the current makeup of the law?
All right, let's take that latter question first.
Yeah.
A statute that covered the entire state would have less constitutional hurdles to clear and would make a better policy. It is a second problem, however, that has led to the situation of the litigation today. It is the enforcement in the name of the preclearance standard that is the subject of the problem. If we were stuck with or saddled with or given circumstances of the straightforward evidences of discrimination, you wouldn't see an argument like the one that Shelby County is making succeed. The problem has become that the Justice Department is becoming much more interested in racism prevention than racism punishment. The police officer goes to the bank and arrests the guy who robs the bank. He doesn't go to the bank and set up standards to prevent bank robbery.
Well,
the police officer also doesn't get to decide, are there more bank robberies happening now or less bank robberies happening? He simply enforces the law. My final point is this. The Justice Department has decided that the number of black elected officials is a proxy for the degree of racism or not that's going on. That's an untested premise. And that is the reason why when you are addressing the sovereignty issue, you can't take untested premises and use them to offset the sovereignty of every given state.
The whole point of Section 5 was to be preemptive, because what was happening is that before 1965, that the Congress or the courts would strike down voter suppression laws, and a new voter suppression law in Alabama would just go into effect. So what Section 5 did, the beauty of it was to shift that burden. The other beauty of Section 5, it was purposefully targeted. That's why it's been upheld so many times. It's supposed to be narrow and deep instead of shallow and wide. That's why it's so effective.
And Justice Kennedy himself, just to say one thing in response, Justice Kennedy, in the oral argument in what we all call the MUD case, the Northwest Austin case, he said, I know Section 5 is effective. I know Section 5 works. And I know the other parts of the Voting Rights Act are not a substitute for it. So the whole argument about this being a bad mechanism is sort of spurious. There's no...
But what about this argument that has some intuitive appeal, which is why not just make it the whole country? If that's the objection, right? And Alito actually, last time around in the oral argument, sort of suggested as much. And Horace just said there will be less constitutionally problematic. Why is that not a good solution?
Well, the truth is that the genius of what Congress did in 2006 is that it surveyed discrimination across the country, to Ari's earlier point. And it looked at those places where discrimination against voters of color was most concentrated and found that the highest concentration, the places where discrimination was most intense, was most adaptive, was most persistent, was in the existing covered jurisdictions under Section 5. There is a record that Congress developed, which we talked about earlier, which spans 15,000 pages, which curiously Horace's brief submitted in opposition to the Voting Rights Act doesn't grapple with at all, which justifies Congress's continued coverage of the existing jurisdictions under Section 5.
Right, this is
I would challenge him to come to Alabama to run for office and see if he could win. And I think that one of the things that we have to also look at the fact is that Section 5 has been the one thing that has leveled the playing field. And I think that if had not been for Section 5, and I'm not so much concerned as about what's going on right now, I'm concerned about what will happen if Section 5 is lifted.
Yeah, can I ask you that question, Horace? Because I think you would agree. I mean, I don't know where you stand on this. That the Voting Rights Act at some point was justified and has been a successful piece of legislation, right?
I don't disagree with that, but I disagree with the idea, as the bishop just pointed out, that the test is how many elected officials of a given race are ultimately successful.
But that's not what he's saying. That's not what, but just for a second, that's not what he's saying.
That is what the Justice Department has been pursuing.
No.
And in fact, the Justice Department, when they now analyze the amount of racism and discrimination, one of their indices is the lack of elected officials. So you can't say that, but that's not the argument.
Hold on one second. You got to take a quick commercial break, and then you can respond.